Peace and greetings to everybody. My name is Faisal Qazi. I'm traveling from California, Southern California area. I'm in private practice neurology. I've had a long-standing interest in bioethics, and I'm involved in a number of endeavors in terms of the study of bioethics vis-a-vis Islamic tradition, including medical school programs and courses as such. Our next session involves two of our speakers. If they may come up, please, Dr. De Vries and Robert Vischer, please come on up and take a seat. The overarching theme of really this session is a discussion of bioethics in the realm of newer developments such as technology and the role of culture and its place in both in the legal setting and really in a cultural setting as we delve into this. I'd like to introduce Dr. De Vries first as he would go. And we are limited to 20 minutes each, after which we would go into question and answer sessions. Dr. De Vries has his PhD, and he's a professor here at the Center for Bioethics and Social Sciences and Medicine at the Department of OB-GYN and Department of Medical Education here at University of Michigan. He's the author of A Pleasing Birth, Midwifery and Maternity Care in the Netherlands. And he is co-editor of The View from Here, Bioethics and the Social Sciences. He's at work on a critical social history of bioethics and is studying the regulation of science, international research ethics, difficulties of informed consent, bioethics, and the problem of suffering, as well as the social, ethical, and policy issues associated with non-medically indicated surgical birth. Dr. De Vries will be discussing really today something extremely fascinating, which is the trajectory of what seems to be developing as a uniquely Western bioethical field, yet it permeates and is processed in other cultures, and certainly your work is going to explore how it is indeed processed and how other cultures and societies have really implemented and indicated to work with it. As you know, in the overarching human experience, in dealing with bioethical issues, there's always been conversations. Roman law, for example, in the 8th century, there was discussion and implementation in situations where, for example, if a pregnant woman dies, how a child should be immediately excised. In the Islamic tradition, prophetic model, we have traditions of the prophet that indicate that if a practitioner, a physician, ends up inadvertently any sort of harm to a patient, that particular physician must compensate the patient. So sort of the idea of malpractice. So the conversations have indeed been taking place. What Dr. De Vries here is going to explore is really the formalizing of this science in this unique Judeo-Christian Western paradigm along the lines of the development of the science of medicine itself. Please welcome.
Thanks, excuse me. Thanks for that introduction, and I'd like to thank the organizers for putting this great day and a half together. And thank you all for coming, and thank Howard for that nice introduction, I think, which will get us on our way for talking about these things today. Here's the problem I want to talk to you about today. Basically, very simply put, when biomedicine travels, it brings bioethics along with it. And I'm really going to look at bioethics moving into new cultures. My challenge for you is to think about the opposite problem, which I think is a perfect parallel, which is people also move. And people move from one culture to another, and they move into cultures with different ideas about bioethics and morality and moral traditions. My focus is on this movement of bioethics from the West into other cultures, but I think it does parallel. So your challenge is to keep that in mind as I talk about this topic. I really see kind of a one-way influence with bioethics traveling across the world, essentially moving from North America and Europe to other parts of the world and bringing with it its own moral traditions and its ways of moral reasoning. Just to set you up, I want you to imagine something with me, and to take it out of the context of the United States, I want to move to another culture where I do some work, which is the Netherlands. Imagine that you're a Dutch bioethicist and you've been invited to Nigeria to talk about a program for delivering dental care to those who don't really have dental care. The subjects in the study won't be exposed to any more than minimal risk of harm, which is the way our IRBs think about these things. But in fact, this is a research project that requires ethical oversight. And the question is, whose ethical standards should you use to have this oversight? In the Netherlands, there's a very well-organized system of research ethics review with a national center and local research ethics committees. And Nigeria actually has IRBs set up, and they have a federal-wide assurance, if some of you know what that is in research ethics, given by the National Institutes of Health. But you know as a researcher that often research is done without IR approval in Nigeria, and even when approval is given, the protocols are not often followed. So we could add more detail to this, but this is the bottom line I want us to think about. Here you are as this Dutch ethicist giving advice to Nigerians. Basically, what you're worried about is that the IRB, even in Nigeria, is going to be using a set of standards based on a completely different ethical tradition. And it's suited much more to a hypothesis-driven way of thinking about modern medical science, and it has nothing to do really with the values of the local population. Another way to ask this question is, can the Belmont Report, which is more or less the Bible of research ethics in the United States and elsewhere in the world, can it work in Nigeria? Can Nigerians use Western ethical ideas to protect human subjects? And there are people who say, sure they can, because the principles of the Belmont Report are universal. Respect for autonomy, beneficence, justice. These are those overlapping comprehensive ideologies that Howard was talking to us about. And there are equally many people, or maybe fewer, who say, maybe not. The principles, even if you modify them, don't really fit with local moral traditions. Let's just consider the Belmont Report in Nigeria and think about Nigerian autonomy or ideas of autonomy versus North American ideas of autonomy. In individualistic societies, we really believe that free and independent people should have the right to decide what's done to them. It's their choice and theirs alone. In communal societies, these decisions occur in consultation with others, and often with deference to the authority of a tribal leader. And so this contrast between, well, what's really autonomy stands out to you as an ethicist. Can you, in fact, as a European, speak of respect for autonomy if you know that in this research trial, decisions about participation will be made by someone else? So what's going on here? This is in looking at how bioethics moves across the globe. I've come up with a little typology. I think there's essentially three ways that bioethical ideas move. One is ideas are adopted wholesale. They're just, hey, you have the Belmont Report. We can make this work in Nigeria. We'll just start doing that here. A second way is, okay, you have these ideas, but what you do is you kind of mold them and shape them and kind of tweak them a little bit and make them fit. So the idea of autonomy, actually, if you think about it, could be applied by saying, well, in some societies, there's a different kind of autonomy. And that autonomy resides in the leader of the tribe or the clan or the village. And finally, and this is the one I want to get us to think about, you can use Western ethical ideas, but only to open a conversation about how you move from a moral tradition to ethical regulations. Let me talk first and in some detail about what I think is the most common way bioethical ideas move, which is wholesale adoption. And I've termed this bioethics as missionary work. This occurred to me when I was doing some work in Europe where students from the developing world were studying Western bioethics. And I noticed that there was really very little attention paid to their moral traditions. And there was really a lack of fit between what they were learning and what they would face when they went back to their home countries. And I think this idea of bioethics as missionary work is an apt comparison. There's a missionary, there's a bioethicist. And that both have really a noble intent. Their intentions are noble. The other commonality is that there's a one-way flow of influence. The missionary brings the gospel to this society and basically wants to inform this new society of all the value of the gospel, the good news. And I think there are dangers of unwitting harm that happen in both cases. Looking at that comparison in a little more detail, mission really means bringing the gospel, the good news, could be the Bible, it could be the Belmont Report. And you find both in missionary work and in bioethics work this interesting similarity. As converts are made, a realization happens that this work shouldn't be done by somebody coming from outside the culture. It should be done by locals in the culture. And I think both in missionary work and in bioethics, we find the indigenization movement going on. And what is that? It means you bring people from local cultures to the West, as I saw in Europe when I was working over there. You train them in your ideas, and then you send them back. Because after all, they know the local culture. And this is done here in the US by the Fogarty Center. In Europe, it's done by the Erasmus Mundus program, which I was a part of, and the UK, the Wellcome Trust. All three of these programs really are indigenization movements for bioethics. And in case you think this is an old idea, Ruth Macklin, who's a fairly well-known bioethicist in the United States, said this at the International Association of Bioethics meetings last year. She's taking issue with this idea that bioethics is universal and doesn't apply to local society. She says, the claim that adherence to universal principles is ethical imperialism is misguided. The principles at the heart of so-called principlism are not peculiarly Western, although their origins may be in the Western philosophical tradition. So these are the problems I want us to focus on. There are different models of ethical reasoning, and when you try to bring the gospel, you have to face that, and different levels of relevance to the local situation. Just briefly, I have a lot more information on this, but I don't have time to share it all. I did some interviews with these bioethicists I was working with in Europe who were headed back to their home countries. And I talked to 21 of them. I asked them what they were learning and how this would apply when they got back to their own countries, and many other things, but I'll just focus on these. And some quick quotes from the interviews talking about, well, what is the source of ethics? This is one of the students. Ethics means Islamic culture, Islamic tradition. We don't differentiate between Islam and religion and ethics. And here's another student from China. If I want to accept all the theologies and the methods for the bioethics for Chinese people, it's a little difficult. We have different religions, and very few people believe in God. They're not Christian. So they have no sort of knowledge about Christian history, about Jesus. So you know, a lot of bioethics and methods and theories come from Jesus, by which he was saying from the Western Christian tradition. I asked them, where did you learn about bioethics? And here, our Wired World shows us something. Most people said, yeah, I basically look at English and American sources for bioethics. A lot of people go to the NIH. Countries in the developing world will use the NIH tutorials to teach research ethics to their people. As we've already heard a little bit, and I'm assuming some knowledge of the principles were developed in the United States, articulated first in the Belmont Report and later in Beecham and Childress's work. And they have these basic ideas: respect for persons, beneficence, and justice. And I think they're very seductive because I do think they can be universalized. And in spite of the fact, as Howard said, people are moving away from this, the actual practical ethical decisions on the ground often use principlism in a variety of cultures because principles are so sweet and easy to apply to problematic situations. And so we find they're very practical and very pragmatic. But do they fit with local culture? I just want to, from the interviews again, a few problems that I saw my students there identifying. Cultural problems. In Islam, justice is more important than autonomy. Islam said first your neighborhood, not first yourself. Someone else said, in rural India, the idea of autonomy is totally different. They don't even sign the admission sheet, not the patient or immediate person, the family signs, even for admission. And then she concluded, we're not thinking of autonomy of the person, we're thinking about the collective autonomy of the whole family. There are also structural problems with the principles. And here again, a student from India saying, look, if you just look at the way India is, it's not structured in a way to allow people to exercise their own autonomy. And here's somebody from South America saying, yes, bioethics is influenced by bioethics in the US, and we get taught the 4 principles, but it's not exactly like the US because we have a national health system, which I think he was tweaking me a little as an American. So the idea of having a principle of autonomy that can overrule other ones when they're in conflict doesn't exist. And then just briefly, if I looked at some of the courses students were taking, and not just in this European program, but elsewhere, they're courses like this: ethics of reproductive technologies, where they learn highly detailed arguments about the moral status of a fetus and how it exists in IVF. Human genetics, learning about new personalized medicine and genetic treatments, all of which, when I talked to the students, said, this is not the ethical problem I'm going to face when I go back to the Philippines or when I go back to my own country. And here's a student saying that in confrontation with my culture, with religion, we want to preserve our culture. We want to preserve our purity. It's easy to destroy that, as the Spanish did in the Philippines. So there's this idea that something's being imposed. And here's a brief summary from a colleague of mine from India, where he says, look, if you look at the history of medical ethics, for example, the reference point is Hippocrates, as if no other medical ethics code existed. How many bioethicists know or even care to know about ancient India or China, and they had elaborate systems of medicine and medical ethics before Hippocrates? And you must be kidding if you discuss here, he's talking about in Europe, Buddha or Confucius or Shankar or even Gandhi for that matter. There's this one-size-fits-all of principles, and they want us to master the acrobatic art of balancing principles and beating off the worst kind of ethical malaise. So in sum, what do I see as the harms of wholesale adoption? Ethical ideas that are imposed rather than indigenous limit useful research by demanding that you have Western standards before research begins. They can disrupt existing moral traditions, creating confusion. And they give rise to cultural brokers who kind of try to stand between these Western ideas and local traditions and do all sorts of negotiating in the attempt to gain status in their local communities. Now, very quickly, I want to talk about the other two ideas. I'm conscious of our time. There are people who say, okay, we'll take these Western ideas, but we'll make them fit in our own culture. And here's an example from Karachi University in Pakistan. If you look at their curriculum, which I've done, the topics are very Western: informed consent, conflict of interest, privacy, confidentiality, rights of patients. It's that right-based idea that comes out of our tradition. And they say in this article by Siddiqui, we're educating our students in the basics of bioethics, using practical examples to highlight ethical issues, but we're trying to keep the social milieu of Pakistan in mind. Another example comes out of the Middle East. This is a US-funded program, Middle East Research Ethics Training Initiative. And in their course, this is a very predominant piece they use, which really stood out to me: Islam and the Four Principles. And this author says Islam has given great importance to what are known today as the ethical principles of autonomy, beneficence, non-maleficence, and justice. But you see here, what I see going on is that here what we're saying is Western ideas are supported by Islam, not that they're ethical ideas that we can get out of the Islamic tradition. But we're saying, hey, you have some cool ideas. Oh, we like those too. And we're never saying, what are your moral traditions and how might they teach us to develop ethical guidelines? And here's a student saying, my role was to have to translate Western ideas. So I have these ideas, and now somehow I have to make them fit in my home countries. You have to always make changes. The cultural, religious, whatever background that you have cannot apply directly to them. So here the idea is adopting Western ideas to fit in non-Western contexts. Now finally, my last point. I think there's another way to do this, and I have to say, this is a theoretical rather than empirical model. That is, I haven't observed it too much out there being done. And this idea would use the knowledge of ethics. Hey, we have to admit we're people with moral traditions, and we bring those moral traditions to the ethical problems we face. But we don't say these moral traditions are the answer to your problems. We say, this is one way we've converted a moral idea to an ethical guideline. Now, let's think together about your moral tradition and how we might convert it to ethical guidelines. That's where the conversation happens. So the focus is on the process of articulating and applying moral ideas. And unlike existing ethics training, this is more inductive. Let's start with the tradition and see what emerges out of this. You start with thinking about local moral ideas. You use the history of moral philosophy as an example of how to implement moral ideas in practice. I think this model turns the existing model on its head, because basically what it says is, we're in a conversation here, and what might we learn from you about how we can do ethics? And what might you learn from us about how you can do ethics? So it's really an inductive, dialogic way of thinking about ethics. Ethics remains helpful. Here's my 2-minute warning. Oh, 5-minute warning. Oh, I'm going to slow down. I was rushing. No, that's great. I'm actually near an end. We'll have more time for questions, I think. So our ideas remain helpful, but not as maxims or things to be done, but as models of how we moved from moral traditions to ethical ideas. And there is one example, and those of you who don't know the work here, I think you'd be very interested to do a little more research. But in Pakistan, at this Sindh Institute for Urology and Transplantation, they have a Center for Biomedical Ethics. And they really are, I think, thinking in this way about how to do ethics in Pakistan. In their course, Foundations of Moral Thought, they focus on the historical contributions of Muslim philosophers to moral thought. And they basically have this idea that we're trying to engage in a constructive critique of secular philosophical bioethics. They look at indigenous values. This is a quote from their course book. They look at cultural and religious norms, socioeconomic realities, and how individuals actually arrive at decisions in relationships between professionals and persons. The leader of that center is Farhat Moazzam. Some of you might know her work, but this is what she says about the need for a local bioethics. It's necessary for us to evolve bioethics in a coherent way in this country, give it a form that resonates with our values. Otherwise, bioethics in Pakistan will remain an academic exercise irrelevant to the needs of our population. I think if this approach flourishes more in the developing world, it will generate an important dialogue about moral ideas. And I think, really, we're going to learn a lot about how we do ethics in this country as well. To me, that's almost as important as making sure we're not being imperialistic in other countries. So quickly, a summary, and then a few recommendations. One of the things I'm trying to get us to think about, it's very difficult to decide, and this was a theme of Howard's talk as well, about whose ethical standards should apply in collaborative research. And collaborative research is happening more and more. You also have the golden rule problem. I wouldn't be a good sociologist if I didn't point this out. And the golden rule is not what you think, but it's he who has the gold makes the rules. And what I've seen in international research is when you come from a country like the United States, you come from an institution like this one, you have a lot of power and authority automatically given to you when you go into a country that's poorer. Also, another point to think about is how cultural brokers manipulate the ethical process. So my recommendations, and this is interesting because Howard and I did not talk ahead of time, but we're coming to a very similar place. This dialogue has to be characterized by mutual respect. These guidelines should reflect local culture and traditions. You cannot assume that one is superior, so we're talking about humility here. I think it's useful to adopt an inductive approach so that you're learning how moral traditions get converted to ethical guidelines. And then finally, the importance of talk. If you reach a moral impasse in your collaborations, you have to talk through the values in question and arrive at a solution that everyone can honor. Thanks.
Thank you, Dr. De Vries. Certainly fascinating to see the globalized consideration of ethical issues. Next, our speaker is Dr. Vischer, or Professor Vischer. He's a professor of law at University of St. Thomas in Minneapolis, and is a senior fellow at the Murphy Institute for Catholic Thought, Law and Public Policy. His scholarship focuses on intersection between law and religion, with a particular concern for the religious and moral dimensions of professional identity. He is the author of Conscience and the Common Good, Reclaiming the Space Between Person and State. And he has published more than 24 articles in academic journals. He also writes regularly for the magazine Commonweal and blogs at Mirror of Justice. He's a graduate of Harvard Law School, where he was an editor of the Law Review. Professor Vischer today is discussing the idea of liberty of conscience. It's a key foundation, as he states, of our legal system. He does make a distinction in this particular book when you go into discussing the principles of autonomy and how it relates to the whole idea of liberty of conscience. And one phrase that you stated really truly summarizes your thesis in there is that although conscience is inescapably personal, it is also inescapably relational, akin to some of the discussion that's taking place by Muslim ethicists and bioethicists, such as Dr. Sajdina, who will be presenting to us today when he discusses communitarian ethic. and rights over responsibility, responsibility over rights. Please welcome.
Thank you. I very much appreciate the invitation to be part of this important gathering. I think the invitation is especially gracious since I'm neither a Muslim or a bioethicist. I feel like an interloper here, but hopefully I can add at least a little bit of value. As he mentioned, my field is law and religion, and I certainly, we could have a month-long conference devoted to the interplay of law, religion, and healthcare. I'm not going to do that. I want to focus down on a more particular question that I think is the most pressing question given the direction I see the conference taking, and that is to what extent is the American legal system likely to accommodate the religious commitments of healthcare providers? I'm not going to talk, at this point at least, about the likelihood that the legal system can accommodate the religious commitments of patients. I think that's a much less problematic proposition given some of the premises of the legal system, but we can talk about that in the question and answer session if you'd like. There's another angle you could take, and that would be to ask, to what extent can the legal system embody the religious commitments of a particular faith tradition? I don't see that as a premise of this conference, so I don't think it's quite as pressing. I also think if that was the premise, it would face much dimmer prospects. And let me explain why for just a couple of minutes. That is the notion that rather than trying to create space within the legal system for providers to exercise their professional duties in keeping with their religious commitments, the religious commitments then become reflected directly in the overarching legal norm that governs all. Now, I'm not going to say that this has never been the case. If you look back, there's been significant overlap between healthcare law and the teachings of Christianity in this country. The past criminalization of abortion and contraception, for example, and current prohibitions against assisted suicide reflect Christian teaching, though defenders of these laws claim, correctly in my view, that these prohibitions are based on broadly accessible moral principles that don't rely on any divine revelation. The perception that they have religious roots undoubtedly contributed to their demise in the case of abortion and contraception bans, and to their recurrent constitutional challenge in the case of bans on assisted suicide. The U.S. Supreme Court has grown suspicious of laws that attempt to answer what it sees as fundamentally religious questions. So in Roe versus Wade, for example, Roe is the case that struck down bans on abortion. The Supreme Court observed, quote, "We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary at this point in the development of man's knowledge is not in a position to speculate as to the answer." Note that the court was not asked to come up with an answer, but simply to permit the Texas legislature to reflect an answer in its own statute on the beginning of life. The weighty and religiously informed, but not defined, question of when life begins was deemed a no-fly zone by the Supreme Court. More broadly and more recently, the Supreme Court has taken a skeptical stance toward laws that limit privacy and personal liberty, especially when those bans are based on moral claims that are not tied to any cognizable harms to be avoided. So in Lawrence versus Texas, a case from a few years ago, the court struck down a state ban on same-sex sodomy. And that was not especially surprising. What was more noteworthy was the reasoning the court employed in striking down the ban. The court suggested that the state's assertion that the ban emanated from the moral convictions of the citizens was not even a rational basis for the law, much less a compelling basis for the law. The Lawrence quote quoted approvingly from an earlier abortion case for the notion that, quote, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." Okay, let me just say that again. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. I'm guessing we could have an entire symposium in exploring an Islamic response to that one sentence, but that's the operative premise for the Supreme Court in some of these cases. Now, Lawrence did not involve a question of healthcare and medical ethics, I just flag it for your attention because it suggests that laws that would limit personal liberty without a justification beyond a straight moral claim face an increasingly uphill climb in our legal system. So the more pressing issue for religious health care providers is whether they will have the liberty to practice medicine in a way that is consistent with their beliefs. In other words, in my view, it's less a time to be playing offense, that is, seeking to conform law to the faith tradition's moral claims, and more a time to be playing defense, that is, seeking to maintain space in which to live out one's moral claims without interference from the state. For the foreseeable future, questions about the relationship between law and religion and healthcare will be questions about the liberty of conscience. Given the morally controversial nature of developing medical technologies and the centrality of healthcare decisions to virtually all modern conceptions of individual autonomy, healthcare is a primary battleground for today's conscience debates. Patients are understandably concerned at the prospect of a provider's moral qualms limiting the available range of treatment options, even if the patient finds the treatment to be morally acceptable. Providers are understandably concerned at the prospect of the state acting on the patient's behalf, compelling them to violate their own moral convictions. So one example I'll just talk about briefly is the rights of pharmacists. Some states now, just about every state has taken this up in some form or another. Some states now have legislation protecting the pharmacist's rights not to dispense drugs that they find morally objectionable, while other states have laws ensuring that a pharmacist's conscience does not interfere with a customer's ability to obtain a legally prescribed drug. Washington State, for example, requires all pharmacies to fill all legally valid prescriptions on site, effectively ending what had developed into the practice, allowing pharmacists to decline to fill a prescription on moral or religious grounds and refer the customer to another pharmacy. The debate has also occurred at the federal level, as some of you have probably followed. Just last month, President Obama replaced the Bush administration's conscience rule for healthcare providers with a narrower version. Supporters claim that the changes are a win for patients, but critics claim that providers' rights have been trampled in the process. Well, conscience clauses have been common since Roe versus Wade. The notion that physicians should not be compelled to participate in a procedure as morally wrenching as abortion has not been especially controversial, and I still don't think it's as controversial as some of these other battles, although it's becoming more controversial. The advent of Plan B emergency contraception has driven pharmacists to seek the same protection enjoyed by physicians. Some pharmacists believe that Plan B functions as an abortifacient by blocking the fertilized eggs implantation. Along with pharmacists' expanded discretion as gatekeepers to pharmaceutical care, the widespread availability of Plan B has really provided a spark for the conscience controversy. But it's now spilled over into the dispensation of other drugs, including the more common birth control pills, and in a few cases, other medications like antidepressants. As pharmaceutical technology encompasses moral hot potatoes such as genetic screening tools, research derived from embryonic stem cells, or race-specific medications, the stakes and the passions will likely be ratcheting up in the future. Now, obviously, the pharmacist controversy is just the tip of the iceberg. Other controversies include debates over whether Catholic hospitals should be required to provide emergency contraception to rape victims, a physician's or a hospital's authority to resist financial and family pressures regarding end-of-life care, and discrimination by providers on the basis of marital status or sexual orientation. Just a couple of examples on that last point. In Ireland, a Catholic physician was part of a clinic dedicated to practicing medicine consistently with church teaching. As such, he declined to provide fertility care to a woman who was not married. He was brought before the board on fitness to practice charges. Fortunately, thanks to Farr Curlin, who's here with us today, he won the case. But the point is, he had to defend himself as fit to practice because of how he had decided to devote his practice. In California, a physician declined to provide fertility care to an unmarried woman who was also gay. There's some dispute as to which was the basis for declining the care, and he was held to have violated the state's anti-discrimination law, and that went all the way up to the state Supreme Court and was upheld as fine, that he could be sanctioned for that. So from a legal perspective, how should we think about these controversies regarding religious conviction and health care? Well, people reflexively want to go to the Constitution and say there's got to be a constitutional right in here somewhere. And there's arguments to be made, but the Constitution doesn't help us sort it out all that much. There is a Supreme Court case called Employment Division versus Smith. And what Smith said is if a law is neutral and generally applicable, the fact that it might burden someone's exercise of religion is irrelevant for purposes of the free exercise clause of the First Amendment. So if you have a law that's neutral and applies across the board, the fact that it might make your religious convictions much, much harder to live out, that's not an infringement on your religious liberty. All right? As such, the cause of liberty in this area is more of a political issue than a constitutional one. It's going to be settled in legislatures much more than it's going to be settled in courts. As a society, we're going to need to engage in a conversation about what the law should be on these issues. Even resorting to the liberty of conscience as traditionally understood is not all that helpful. We're used to the law defending conscience when the individual is pitted against the state. Right? The classic examples of liberty of conscience are the individual inducted to serve in the military, or back in the early 20th centuries, a Jehovah's Witness student being compelled to participate in the Pledge of Allegiance. Those are the classic liberty of conscience cases. The individual against state power. It's very easy to figure out whose side conscience is on. It's the individual. But now, when the battle is between provider and patient, right, how does conscience shake out in this context? It becomes much more complicated. And the inquiry is complicated even further by what I see as three primary trends that we need to be aware of. So let me just spend a few minutes outlining those, and then I'll close. The first trend: much of our political discourse reflects a changing view of professional licenses, moving from what I see as a competence regime to a normative regime. The easy response to any call for a professional right of conscience is, look, you may have a right to conscience as a private citizen, but state licensed providers are like public officials. The right to conscience doesn't apply. Along these lines, the New York Times editorialized that pharmacists who refuse to dispense contraceptives are engaged in an intolerable abuse of power and need to find another line of work. The National Organization of Women went higher up the chain of being, labeling such pharmacists as extremists arrogantly playing the role of God. Among the problems with this argument, in my view, is that it rewrites the history and purpose of professional licensing, which has traditionally been aimed at ensuring competence, not at co-opting providers into serving state interests at the expense of their own moral agency. Lawyers, for example, are free to decline representation that they find morally repugnant, and the bar's licensing inquiry focuses on competence and character, not on the lawyer's willingness to take on whoever walks into the office. Now, it doesn't translate directly into the medical field, but there's still there's a changing focus from competence to the other in some of these arguments. We want professionals to be morally engaged with the work they do. As the 20th century made all too clear, we take on significant risks when we encourage, much less require, the professional's role to define the professional's conscience. The second trend: there's a trend away from rights as negative liberty, that is, prohibiting the state from interfering with one's pursuit of what they deem to be the good, toward rights as a positive liberty, that is, empowering individuals to enlist others to help in their pursuit of what they deem to be good. This makes the question of religion and healthcare much more complicated. We recognize that the existence of a legal right does not mean much absent ground-level empowerment to obtain the good or service to which the right is attached. This dynamic is especially apparent in the reproductive rights arena, where the focus has shifted from decriminalizing abortion and contraception to insisting that the individual must have unfettered access to abortion and contraception. Not only should the full range of pharmaceuticals be available at every pharmacy, but they must be provided, in the immortal words of former Illinois Governor Rod Blagojevich, with no hassle, no delay, no lecture. The fact that the state can't forbid the provision of a particular good or service is taken to mean that every good or service must be provided by all licensed providers. In the process, the moral convictions of providers are rendered irrelevant. The individual consumer or patient does not just coexist with the morally divergent views of the provider. The individual, backed up by state power, trumps the provider. I don't mean to suggest that access to morally controversial goods and services is not an important public value, but the enshrinement of universal access as a precondition for participating in the healthcare market imposes significant costs on other important public values, the liberty of conscience most glaringly. Medical rights as a positive liberty result in a strangely amoral vision of healthcare. The former Democratic governor of Wisconsin, for example, justified his veto of a conscience bill for healthcare providers on this ground. He said, quote, "You're moving into very dangerous precedent when doctors make moral decisions on what medical care they'll provide." unquote. I would argue that you're moving into very dangerous ground when a governor rejects the possibility of doctors making moral decisions about the care they'll provide. The third and final trend, many supporters of an individual right of conscience are more skeptical of extending those rights to an institution. Even if we're comfortable with an individual physician having a right not to participate in a controversial type of care, we might resist giving a hospital or clinic the power to withhold the availability of a certain service. In my view, this resistance is unfortunate because it marginalizes the institutional liberty that is essential for the long-term flourishing of conscience. For example, the rise of small pro-life pharmacies is viewed with dread in some quarters. Institutional liberty appears more threatening than individual liberty. The ACLU recommended in a report advocating for laws requiring pharmacies to satisfy any lawful request for birth control that, quote, institutions when operating in the public world ought to play by public rules. I would agree with that to an extent, but I would say we need to be careful about how stringent we want to make those public rules when they intrude on the possibility of institutional identity. Viewing institutional market actors as an extension of the state does not bode well for the liberty of conscience. The state honors its citizens' claims of conscience by ensuring the conditions necessary for the moral conversation to continue, not by imposing one set of claims over another. In my view, one key to navigating these tensions in the future is to recapture what I call the relational dimension of conscience. That is, the notion that the dictates of conscience are defined, articulated, and lived out in relationship with others. American law has traditionally had a very individualized conception of conscience, and we need to work toward expanding that conception. Our consciences are shaped externally, our moral convictions have sources, and our senses of self come into relief through interaction with others. By conveying my perception of reality's normative implications, my conscience makes truth claims that possess authority over conduct, both my own conduct and those who come to share my views and over their conduct as well. Conscience, by its nature, connects a person to something bigger than herself, not only because we form our convictions through interaction with others, but also because we invest those convictions with real-world authority in ways that are accessible, even if not agreeable to others. Conscience might be expressed and defended by the individual, but its substance and real-world implications are relational by their very nature. Cultivating and maintaining these conditions necessary for these relationships to thrive should be a priority for our society if we're serious about freedom of conscience. Now, let me wrap up by noting that I'm not an expert by any stretch on Islam or its past relationship with American law. But I will note that the political dimension of this relationship is even more complicated in the Islamic context, in significant part due to the near hysteria in some parts of America regarding the perceived threat posed by Sharia law. Addressing religious liberty at the institutional level becomes more complicated for Muslims because of our society's knee-jerk assumption that institutional efforts to either reflect or accommodate religious convictions are somehow equivalent to the legal enshrinement of those convictions. Hence the controversy in some circles over something as simple as banks offering Sharia-compliant financing alternatives, or the Oklahoma law recently passed banning courts from considering Sharia law. Now, this statute pulls off the very difficult task of simultaneously violating both the Establishment Clause and the Free Exercise Clause, in my view, which is a very rare trick. They do that. But for our purposes, what's relevant is the premise of this law. The premise of this law makes it extremely difficult to have a distinct institutional identity if you don't know that the rules on which the institutional identity is grounded will be enforced in a court of law. That's what makes it so difficult. Excellent. Just about done. I can't see the future on this, but the current public mood poses additional hurdles for Muslim providers to live out their faith commitments at the institutional level. I think that much is fair to say. Regardless of the policy resolutions reached in a specific healthcare dispute, in my view, it is important to reorient the conversations about law and religion and healthcare toward what is at stake. In a functioning marketplace, the viability of conscience requires us to give providers and like-minded customers an opportunity to live out their faith commitments. By more steadfastly defending the social space in which individuals and groups can live out the dictates of their consciences, even when, especially when, those dictates have been rejected by the majority, we will bolster the long-term prospects for the liberty of conscience and the possibility that a Christian or a Jewish or an Islamic bioethics can be lived out in the real world. It's not just about the individual and the state. There is important space in between, and it's conferences like this one that can help nourish that space. Thanks very much.
Thank you, Professor Vischer. I think aside from just really the way law looks at issues and principles like autonomy and privacy in the legal terms meaning something altogether different than what lay people, even some of us might think of these days specifically. When we talk about privacy, we look at just really FBI surveillance of Muslims. But beyond that, I think we don't, as providers, we often don't realize the degree to which law and the series of court cases really evolved our understanding of ethical considerations. When earlier court cases, when they discussed issues of termination of care, there wasn't literally any focus on futility of care, for example. So from a provider's point of view, that's a little bit counterintuitive. But really appreciate your comments. Let's move into a question and answer series. We have, I think, 10 plus minutes. Please go ahead.
With respect to the last speaker, I'm concerned, are there parallels between liberty of conscience and ethical imperialism? Parallels and perhaps perils. Thinking about the local perspective and the trend recently for Catholic hospitals like St. Joseph Mercy Hospital to buy up public hospitals like Chelsea Hospital and Celine Hospital, and then what are the implications for the ability of patients of diverse religious backgrounds to get the health care that they need. I think we have to be careful about allowing the focus to be shifted to individual conscience, because it seems then to be focusing away from the importance that physicians care for patients. And I think our focus as physicians needs to remain on the patient and not on the physician. Thank you.
Great. Great question. I rely on this audience to get right to the hardest point. The hardest point for me in terms of institutional identity is hospital mergers, right? Because I would say it's not just the fact that you have, for example, a Catholic healthcare provider who doesn't provide all services, because what you need to compare that to is the possibility of not having any healthcare provider at all in that community. That's the possible baseline. Mergers are harder, and I don't have a firm opinion on that. What I am not arguing for is, I'm not arguing to say that we should not pay any attention to securing access to goods and services that are deemed fundamental by the political community. What I am saying is, I would like the political community to make a deliberate judgment that this good or service is fundamental and we must ensure access to it now. What I see in many of the arguments in the pharmacists and other contexts is almost a dignity-based argument that a individual should not have to put up with claims from an institutional perspective or an individual provider perspective that inconvenience them in any way. So where this really came to the fore is in Illinois when they passed the rule requiring all pharmacies to provide all legal pharmaceuticals. It arose from a case where a woman was denied Plan B at a pharmacy in downtown Chicago, and there was one directly across the street she could have gone to get that same product. That's really what I'm pushing back against. I'm, for these purposes, agnostic about what goods and services are deemed fundamental. I have my own views, but what I would like to move towards is making that deliberate judgment that yes, this is a fundamental good or service, and then we can do things necessary to ensure access to it, rather than just have the default rule be all providers provide everything.
Thank you, both of you. My question is for the second speaker. And I wanted to invite you to speak a little bit about the role of gender in the world that you described, because every person who was turned away in your examples, including just your recent one, was female. And they were being refused contraceptives or abortion or whatever, or fertility services. So how does that fit into your analysis? Thanks.
Well, it fits into my analysis that if there's a perception that that women are being disempowered through the exercise of conscience by providers, I would want to ask the follow-up: disempowered in what way? If it's depriving of access to a good deemed fundamental, I think that the state should step in. In Washington State, for example, there was litigation about the new pharmacy rule, and the state in favor of the rule came in with 5 case studies of women who went out as test cases to try to obtain Plan B. In all of those cases, the woman obtained Plan B, right? In a couple of cases, they had to go to another pharmacist across town. In other cases, another pharmacist on duty helped them out. They all obtained that. So then I asked, okay, so what's the disempowerment? If it's a dignity-based disempowerment, I'm very concerned in a pluralistic society of using dignity-based concerns to impose one template on all providers. I'm not saying it can't be a good thing, but there are tremendous costs to it, and I would just be concerned. One quick follow-up. I'm not saying that these providers should be immune from marketplace reprisals for their conduct. If there's going to be a boycott or there's going to be protests, I'm all for that. That's how the market should work. What I'm leery about is the state closing down the conversation by coming in and just, shutting everything down. But great question. Thank you.
We have time for one more question.
Yes,
Go ahead.
thank you. It's more of a comment and a question, and it's for Dr. De Vries. My name is Aisha, and I'm from UK. You were talking about 3 modes of transport of bioethics, adoption, adaption, and then you were more open to conversation between cultures. Now, I'm doing field work, and I'm doing it in Pakistan, and I'm doing it in Lahore. And I'm also for that inductive approach to bioethics. And what I'm looking at is not just indigenization of bioethics, but the indigenous ethics at play, in the field, what it is. And Lahore is not bioethically enlightened, as I would put Karachi to be bioethically, where Dr. Muazzam is. And I've seen that there is a lot of heterogeneity. There's a lot of practice which is different. I've done 6 institutions, and all the institutions had different ways of dealing with problems of informed consent and communitarian consent and all that. And I come to the conclusion that the uncritical acceptance of the local practice, as well as the uncritical adoption of the ex situ principles, are really not the way forward. What is needed is to look at what is happening on ground, and at the same time raising their awareness to other ethical perspectives. Because what I saw, and now on this I would like your opinion, what do you think that, the uncritical acceptance of what is happening on the ground, or the uncritical acceptance of the principles from, abroad, are really not the way forward? What would your comments be on that?
Yeah, thank you. I think that's a great question. And it is a tension in the work I'm doing. In fact, some folks who work internationally on ethics issues, when they read my writing on this, say, you're opening the door to all sorts of abuses. And that in the past, companies have come from the West and said, oh, well, we just need the head man to sign, and everybody in his village can then participate in a research trial. And there's been serious negative effects of that. And I'm aware of that, and I see that as a tension. But my idea, and I have to admit to be something of an idealist and maybe an optimist, is that there's a conversation happens. And so it's not just, I think too often we can say, well, we're the imperialist West. We have to only listen and we can't say anything. I really see this as a dialogic process where we point out how certain values are being realized or not realized by a set of guidelines or ideas about how you regulate research or care given in health institutions and that sort of thing. So maybe I'm idealistic about that, but I think that's the beginning of saying it's not just what you do here. There are people doing things elsewhere, and people are being harmed by what you do according to my ideas. Can we have a conversation about that?
You know, I agree. That's exactly what I'm getting at. There should be a conversation between cultures rather than accepting what's going on in one place or importing, like you said, from other places. So that's what I meant, that I agree with this conversation between cultures and then adapting and adopting, no. First seeing what's happening down there, and if you see there's harm coming because of that, because, you know, my field work showed that there were certain practices like, you know, if women wanted to come to get into a trial, like cancer drug trials, their husbands would not either bring them, you know, take them to other alternative. You know, we have a lot of alternative medicine there.
Yes.
You know, homeopathy, Dam, Darud and all, and then they would bring them towards the last stages. So that is where I thought the tension lay, that if only they were aware, or if the doctor could make them aware that it is her right to come, if she wants to come for her treatment, rather than just being, you know, told that, no, we'll go to other places, and then if all else fails. But then there were other practices where they would just listen to the, you know, the woman of the house, and if she wanted to do it, they would do it.
Yeah.
So I thought in both, you know, there was a lot of heterogeneity. So, you know, in both I thought that we should not be accepting everything that's happening there, but at the same time, we shouldn't be accepting everything that's happening abroad.
Well, let me add this. I think, you know, I'm a sociologist. I don't think I said that, or I'm not sure you said that. But when we think about religion, we often think about prophetic and priestly traditions. And I think in thinking about moral traditions, often the priestly somehow forgets the prophetic. And moral traditions can be used to criticize moral practices, so that certain moral traditions might have developed a way of being that is contrary to the prophetic tradition. And I think sometimes you can criticize from within the moral tradition and say, your tradition preaches respect. How is what you're doing being respectful of this woman? So those kind of things. I know Christianity better than Islam, and I know that you can criticize Christianity from the New Testament. Thank you.
Thank you for your question and perspective. Thank you, Dr. De Vries and Professor Vischer. I think time to move on to the next session.